Good morning. I'm Robert Strassfeld. I'm a law professor here at Case Western, and I want to welcome you to the second day of the Symposium on Corporations and Their Communities. About 30 years ago, not very far from here, the struggle between corporations and communities centered on the question of abandonment. Labor unions and communities fought when corporations were picking up and leaving their communities. The issues of capital flight obviously continue to be very important, but these days another issue has come to the fore, which is the efforts of communities to restrict the community, access to the community by corporations, to keep big box stores in particular out of the community. And that will be the topic of this morning's first panel. And I can't think of a more appropriate group of people to address this topic. So let me introduce them. Let me do that quickly because they have much more to say than I do. And I'll do it in the order in which they'll be speaking. So first will be Dean Patricia Salkin of the Albany Law School. Dean Salkin is the Associate Dean and the Director of the Government Law Center. When she is not helping the law school to run smoothly as Associate Dean, she teaches, amongst other things, land use planning, has written extensively, volumes, in fact, on zoning and land use. She will be followed by Catherine LaCroix. Catherine is formerly a partner at the law firm of Hogan and Hartson in Washington, D.C., where her practice centered on environmental law and including environmental law and real estate issues. She is an adjunct professor of law here at Case Western, where she helps the law school to run smoothly by teaching countless courses that we need her to cover. Most relevantly for this morning's discussion, environmental law and land use planning. And finally is Brannon Denning, who is Associate Professor of Law at the Cumberland School of Law at Samford University. I assume you help the law school to run smoothly, or are you a disruptive influence? I hope. Professor Denning teaches an array of constitutional law topics, has written a shockingly large amount in a short period of time on a variety of constitutional law topics, including recently an article in the Urban Lawyer on big box stores, the effort to regulate big box stores, and the Dormant Commerce Clause. And with that, I will get out of the way and let Dean Salkin take over.
Good morning. I want to thank Adam and the student team here at Case Western, and also the staff for all of their wonderful support in getting me here today. I'm going to focus on what I call formula retail. There's lots of different names that keep going around. There's a group that I'm going to tell you about in a little while called the New Rules Project that sort of expanded our thought process on big box to include all different kinds of businesses that might not be as big, but that might have an impact on community character. So just to start with the basic definition of formula business, we'll call it those that offer standardized services, methods of operation, including chain stores, chain restaurants, and chain hotels. So a lot of what I'm going to talk about today is not just Walmart and Home Depot and Target, but it might be the CVS, the Eckerd, and your small hotel motel chains. The state of Maryland actually offers 4 different categories for these kinds of businesses. The discount department stores, which are known Walmart, Target, Kmart, and they group them by size, about 80,000 to 130,000 square feet. Another group is they label category killers. These are Circuit City, Office Depot, Sports Authority, Lowe's, Home Depot, Toys R Us. Again, they've got a niche market and they sell just certain inventory, and they could really kill the market on the price. And those kinds of stores typically range from 20,000 square feet to 120,000 square feet. Then you've got your outlet stores. You can hardly travel any place these days without seeing the outlet mall. And these are all the stores that sell discount what the high-end retail stores might sell. And those stores are about 20,000 to 80,000 square feet. And then the last category is the warehouse clubs like the BJ's, the Sam's, and the Costco's. And they are much larger at about 104,000 square feet to 170,000 square feet. Sometimes communities want to lock them out, and hence the chain around this big box retail store. But more often, communities recognize that they're not going to necessarily keep them out because there are people that want them, but they can regulate them, and most people want responsible regulation. So this is just, I thought, a neat cartoon, because part of what we're talking about and the rub here is how we're going to deal with the existing mom and pop stores that can't compete on price with the larger stores that have better buying power, and what is better for a sense of the community, what is better for the local economy. So why communities and formula businesses conflict, you know, beautiful view of the mountains with Walmart right in the middle. And so a lot of this is about community character, which means the sense of place. Tony Hiss's great book, dealing with aesthetics, dealing with traffic congestion in areas that might have been rural or more rural before. How does this impact on historic preservation of communities? And what is this doing to sprawl? Because would we see anything else here in front of the mountains but for these types of development? And this is just another picture that I think makes the case even clearer as you're driving down the road and viewing the landscape. Is this what we want to see? Well, in addition to those kinds of aesthetic issues, communities also find reason to conflict with formula business on a whole host of other topics. So, for example, the economics issue. Lots of communities have tourism-based economies and are concerned that people come to our quaint town because they're going to get restaurants, they're going to get stores, they're going to get to experience something that they can't experience anyplace else in America. So if every tourist-based economy had the same Starbucks and the same McDonald's and the same Walmart and the same everything because it was national or multinational retail, that takes away the sense of place, it takes away a motivation, and has a great impact on the tourist economy. And as I mentioned again, the impact on the long-standing businesses, and there's a question as to whether or not constitutionally we can zone to protect or to prohibit competition, and I'll talk about that in a minute. There's also a whole area of law developing on contributions versus the drain on the local economy and resources. Let me give you an example. There are a bunch of articles out there that talk about, okay, so can local governments incentivize these businesses to come in because they say, we're going to help the economy, we're going to provide jobs. Well, when you start to dig down, a lot of those jobs aren't local jobs. They're jobs bringing people in from the outside temporarily or as part of the workforce, except that the jobs aren't from people who live in the community. Then once the tax incentives dry up and the municipality expects some of these businesses, not all of them, and not in every location, to pay their fair share of the real property tax, all of a sudden assessments get challenged, and payments aren't made, and years go by while legal fees are piling up, and the local government that has a limited budget doesn't have the money to pay its bills from what they thought they were going to get from bringing in this diversified tax base for them. And so that has created problems. Another area, it's been a drain for lots of local governments, particularly some of the big boxes. I'll speak for my own hometown. I live now probably less than half a mile from a Walmart that went in about 3 or 4 years ago. And lots of argument in the community about it. People tried to suck me into fighting the Walmart, which I did not get involved with because taking the high road, our zoning ordinance allowed for it, and our comprehensive plan allowed for it, and I really didn't think we had a solid legal argument, so I didn't want to be seen as part of that group. As a resident who lived less than half a mile away, I wasn't exactly thrilled with it, except that that's what the law allowed, and the law was not going to be changed at this point because people were concerned about a diversified tax base. Well, one discussion item that came up is, well, what about the police department? And everybody said, oh, it's not going to have an impact at all, and just because there's a Walmart, it's not going to increase crime, and we went through this whole big discussion. Well, follow the newspapers, a year and a half later, the police department has had to hire additional police officers specifically to respond to all of the calls at this Walmart. There are guns, there are knives, there are things that we have not had in the community as long as I've been there, for about 17 years. So, you know, I do think that there are a host of other kinds of issues that come up that government has to pay for because government has to be there to provide the police presence. Then a whole other area that is the subject for a totally different panel, but something that is relevant because, you know, everything in land use, all politics is local, as Tip O'Neill used to say. You know, it's what the people think and why the people want government to do something about this. Well, in lots of communities, there's a social equity agenda that disagrees with a lot of corporate policies. For example, they disagree with the wages. They disagree with the insurance, the lack thereof, that some, not all, of these retail formula businesses provide. The idea of jobs in the community or jobs out of the community, anti-union policies, outsourcing, purchasing of policies, using labor from overseas at probably not appropriate compensation levels for human beings. And so, you know, you could get caught up in that, but it's whether or not that's a solid justification for municipal regulation. So I'm going to stick primarily with zoning, with aesthetics, with historic preservation. And again, these are just to refresh our recollection, some pictures to bring back the idea. And again, a McDonald's right at the foot of the mountain. So it's not just Walmart. I'm not picking on big box. This is actually a McDonald's in California in, I don't know if I'm going to pronounce the name of the municipality right, Ojai, O-J-A-I. And because this McDonald's went in October of 2007, this community adopted a formula-based business ordinance in order to make sure that things like this won't happen again. So there are 3 general strategies that state and local governments might use to regulate the impacts that these kinds of developments might have. There's land use planning and land use controls. We've got specific state enabling acts that give local governments the authority to do this. But then we also have some states like New Jersey and Vermont that have programs and guidelines at the state level specifically dealing with big box. And so, but primarily land use is a local government issue, so we're going to talk about some local laws and ordinances and local programs. There's environmental review, which somebody else, Catherine, is going to speak about this morning. And then we have a host of economic regulations, which again could be the subject of a separate panel, but I want to just mention some of them. These are things that local governments are doing specifically in response to these types of developments. A lot of local governments are enacting living wage ordinances. That's not new. It's been going on for years, but the focus there is on the local workforce. Minority and women hiring requirements for municipal contractors, for projects that are going in. A lot of this comes under the subject of community benefit agreements. And again, a whole day could be devoted to CBAs. I put a paper in your materials that talks about this. This is where the community groups negotiate with Walmart, for example. You want to come in, you don't want us to oppose your application, let's have a separate private agreement between the developer and the community groups. All kinds of issues, who represents the community and whether government should be a party to this, whether government should adopt these CBAs. It's a developing area of the law, but it works when you have large corporations coming in. A lot of municipalities are starting to use economic impact review tools. The focus tends to be on the local economy. Jobs and wages are included. Just some examples of recent economic impact reviews that you can find on the internet. Bennington, Vermont, conducts community impact studies for large-scale retail. Carbondale, Colorado does community impact assessments, as does Greenfield, Massachusetts. There are dozens of examples. Some of the factors that these economic impact reviews are looking at: the economic effect on existing retail, supply and demand for retail space, redundancy of retail goods and services offered, job creation, wages and benefits, sales revenue to be retained and reinvested in the community, municipal revenue to be generated, municipal capital service and maintenance costs to be incurred, public subsidies to be used. And again, the economic impacts, because sometimes they may be positive, need to also be balanced with the environmental issues. And then a number of local governments are starting these local currency programs. So in Berkshire, Massachusetts, they have something called the Berkshire Buck. And you can go and buy these local currency at a discounted price, and then when you go to purchase goods in locally owned stores, they take that currency instead of U.S. currency, and they keep that currency recirculating within the community. And of course, the formula retail doesn't like it because they want the corporate dollars going to corporate headquarters someplace outside of the community, and a lot of their employees are not coming from within the community, so they don't want to get paid in the local currency as well. But this is something that more and more communities are exploring, whether or not they want to set this up. So I'm going to pass over environmental regulations and get right into land use regulations. And this is where I'm going to spend my next 10 minutes or so, just talking about how to address some of these issues through comprehensive plans, zoning ordinances, site plan review regulations, historic district ordinances, formula-based ordinances, and then lastly end up on the notion of coordinated review, which is the paper that is also in your materials. So we use our comprehensive land use plans as the basis for supporting our zoning or our land use decision making. So it's important that communities have a plan, that they know what it is that they desire to be, that they take inventory of what they are. These are just some examples. I'm not going to read them to you, but examples of the kinds of goals that you find in comprehensive land use plans in municipalities across the country that indicate support for zoning ordinances and other land use controls that have the effect of limiting or regulating formula retail. A recent California case said that the objective of promoting diversity of retail activity to prevent a city's business district from being taken over exclusively by chains is not a discriminatory purpose. And so again, we'll talk more about that with Brannon at the end of the panel today. Zoning ordinances are really where most of our land use regulation comes, although some of the other things I'm going to talk about are obviously not zoning. Zoning regulates the use, the location, the density, and the size of various things, uses that might go into a local government. We might regulate where large-scale retail can be placed in more intense zoning districts. Downtown commercial districts may have stricter regulations. We could use zoning to encourage infill development. So in downtowns that really might be depressed, some of the formula-based retail, it would be great if we could get them to locate there as opposed to the green space, which is creating and adding to a sprawl problem. And a lot of this is negotiation with the municipality and the developers coming in, but the municipality's got to have their inventory, they've got to have their act together in order to make this happen. Another important thing that you can include in your zoning ordinance, specifically as it relates to formula retail, are decommissioning provisions. Kind of like the decommissioning of cell towers, when the building has outlived its usefulness, rather than it creating what is now called gray fields, the empty, abandoned Walmarts and Kmarts and Ames and so forth, and grocery stores, you know, have the developer put some money in escrow or post a bond so that the building comes down when it's no longer used. If you go onto the Walmart website, you will find hundreds of pieces of property across the country that Walmart owns that are now abandoned buildings that are for sale, but nobody wants to buy them. And so the communities are suffering with these types of boxes that can't be retrofitted. Although there are some examples of places that have retrofitted them, by and large, they remain vacant. This is just an example of a new zoning ordinance provision that was adopted in Albuquerque, New Mexico in August of 2007. It applies to retail suites that are 75,000 square feet and greater. It addresses appropriate locations, roadway, transit capacity, street access, appropriate design. It does not prohibit large-scale formula retail, but it regulates it. In Palm Beach, Florida, there is a zoning designation under which stores larger than 2,000 square feet, which is everything, and everything that falls under formula retail, has to demonstrate that at least 50% of their customers are locals. And again, this is part of the community character movement, and this was upheld by the court in the early 90s. Site plan review regulations, this works independent of zoning, but it is another form of local land use control. It basically addresses what does the project look like? How does it fit into the community? And so it might look at things like entrances. It might look at, well, how do you want the store? You typically think of a Walmart and you think of just the one sign, the one major entrance, and it's got a long empty wall between that and maybe if it has a grocery store or a garden shop at the other end. Well, the idea of linear stores is just basically putting up facades that give the appearance that there are other stores in here. It looks like a strip mall instead of looking like one standalone big box. You can look at parking spaces, where the parking is going to go, setbacks, sidewalks, berms, pedestrian and bicycle access, community space on the property, exterior lighting, and signage. A whole other area in signage dealing with aesthetics regulation. Courts have upheld regulations where the municipality said, there's one famous case, Lisa's Party City. Party City is trademarked their logo where each letter of Party City is a different color. And the local government said, well, if you're going to be in this area, all the signs have to be in red. And they said, well, that's a violation of the Federal Lanham Act because we've got a trademark on a multicolor sign. And the court said, no, it's not a violation of the federal statute. You can have a sign. The sign has to be the color that the municipality wants it to be. And so, again, that was a victory for aesthetics. In Gunnison, Colorado, they have a site plan review for large retail development that, among other things, looks at building location and it looks at landscape buffers. And they have a provision in there that talks about residential protection. And it has limitations. This, to me, sounds more like zoning than site plan review, but it says that you can't site one of these within 100 feet of an existing residential development. And so again, this is just some visual of the typical Walmart parking lot, but you can have something that looks more like the Kroger store, less parking in front and more parking in back. And so keep the cars out of view. Again, it helps with the aesthetics driving down the commercial corridor. So I've covered that. Architectural and design regulations. A number of municipalities have enacted these detailed regulations specifically for large retail establishments. They often go hand in hand with the site plan requirements. They look at the no unbroken facades, what do the roof details look like with performance-based kinds of criteria. They might have pitched roofs instead of just the flat roofs. They may require that, which again is not the formula retail method, which is architects just give us, one or two drawings, one or two plans, and we're just going to go and build the same thing every place else. Communities are successfully fighting back from that. Landscaping, entryway details, and so forth. This is an example of what our typical unregulated big box retail might look like. And then these are some pictures of what they look like or could look like with regulations. And so the one on the right-hand side is an example of the linear facade. It's just a Walmart, but it kind of looks like there's other shops in there, and it looks like the walkable kind of area. The one on the bottom looks like you're being invited, you're welcome to this place. It almost looks like the corporate headquarters, but it's a retail store, and because they haven't put parking through the entire front like you see most of the time. And the one on the bottom in front of the mountains, again, just trying to get the pitch to go along with the scenery to make it a little bit more aesthetically pleasing. And the one in the top left-hand corner, I just think that if Frank Lloyd Wright had to design a Home Depot, that, here you've got taking into account some of the environmental considerations and the aesthetics. So this is an example of some pictures of how using historic preservation ordinances and laws, you can still cite these formula-based businesses. So this is a Burger King in Paterson, New Jersey, keeping with the industrial feel and tenor of the community. And this is, the bottom is a McDonald's. Doesn't even have the golden arches. It's a McDonald's in Freeport, Maine, that's located in a former sea captain's house, which even has changed the menu to serve lobster rolls. But it's just an example of what municipalities can do if your attitude is, we're not keeping you out. That's not where we're starting. We're starting with a discussion of, we don't mind if you're here, but you have to abide by the regulations, and let's see if we can work through this together. Even though the corporations come in, and they come in with their attorneys and say, this is our formula, this is what it's going to look like, we can't not have the arches, we can't not have the sign, we have to have a certain size. It is not true. But for lots of local governments that don't have the money and the time to go through the negotiations and to prepare the memos that say you're wrong, we wind up with things that are not necessarily the way that communities would want them to be. I just want to mention on the historic district regulations that the National Trust for Historic Preservation has gotten commitment from 4 of the major drugstore chains to not demolish sites that are listed on the National Register of Historic Places, and meaning that they're going in and retrofitting the inside of the buildings and that they're keeping the facades. But this has been a major effort on part of the National Trust. The formula-based business ordinances, again, I mentioned that the New Rules website is a great place to go if you're interested in this area. The New Rules Project has something called the Institute for Local Self-Reliance. It's based both in Minneapolis and in Washington, D.C. Their mission is to provide a conceptual framework, strategies, and information to aid in the creation of ecologically sound and economically equitable communities. One of their initiatives is called the Hometown Advantage, and the purpose is to help expand, develop, and protect locally owned retail businesses. And that's where a lot of the formula-based ordinances are coming from. And the staff that works at the New Rules Project are really the ones that are the consultants helping municipalities around the country to develop these formula-based ordinances. So some communities have tried to prohibit them outright. Most of them tried to regulate them. A number of them are putting caps and saying you can't have more than 9 fast food restaurants in the municipality. So first 9 in, you get it. Then you have to wait for one to close if somebody else wants to come in. So again, formula retail definitions, a type of retail sales activity that is identifiable basically because they have this standardized array of services, merchandise, trademark, logo, service symbol. These are standard definitions that are just floating around that municipalities are borrowing from one another. Another definition, this is out of San Francisco. It says it's an establishment which, along with 11 or more other retail sales establishments located in the United States, maintains 2 or more of the following features. So it looks to see, do you have other corporate kinds of establishments that are of the same chain? And some look to the number. So it could be something small that maybe you don't hear of all across the country, but it's more regionally based. And so, again, these are just examples of the kinds of formula-based business restrictions that there are across the country, the kinds of things that they might regulate. And again, I'm taking this from the bottom listing of all of these municipalities, and I was able to access all of these online, so, and more. They might limit the street level frontage to 25 linear feet maximum. They limit the total floor area to 2,000 square feet, sometimes more. They prohibit drive-through facilities. They limit formula retail to 1 per building. They limit formula retail establishments to 1 per lot, less than 40,000 square feet, and 1 per 20,000 square feet for lots where there are more than 40,000 square feet of lot area. All different kinds of things. These are just basic kinds of general approaches that are then tailored to meet the specific desires of the individual municipalities. Brannon's going to talk more about whether these and other kinds of regulations are constitutional. I think it's a developing area of case law, and these are just 2 examples that we'll talk about later where the courts have reached different conclusions. Of course, the facts are slightly different. And then lastly, another thing that local governments have that can be an effective way to deal with regulating these kinds of formula retail is to look at things on a regional basis. You know, do we really need to have 2 big box retail of the exact same chain, the exact same store that are located in neighboring municipalities and they might be 2 miles apart? You know, there are all kinds of regional traffic impacts, regional environmental impacts, and so forth. Maybe we could start to look at these together, and that's what the Vermont article started to address. Some states provide specific statutory authorization for this, but lots of local governments working together, independent of formalized regional planning entities, have been successful at dealing with this. And Cape Cod Commission, the Vermont Act 250, as I mentioned, New Jersey, also are examples of states that provide some guidance, and sometimes I'll step it up and say more than guidance, some direction, but the direction is something that's a little bit less than a statute. The state of Maryland recently put out a report, a technical report on big box for local governments, giving them some ideas and examples of strategies that they could use in order to effectively regulate this. So my concluding thoughts, communities have a number of tools that are available to regulate the size, the location, and the aesthetics of corporate retail and service outlets. And again, I just don't want lost in all of this that it's not just the major big box, that it's also restaurants, that it's also hotels, that it also could be the retail, the Gap store that is on, you know, on every street in a tourist community where people might rather have jeans or sweatshirts that say something from the locality where they're from, where they're visiting. But whichever regulatory tools a community chooses to employ, for those of you that might get involved consulting or advising municipalities, we just need to go back and make sure that we've got constitutional authority for what it is that we're doing, that we have statutory authority if we need it beyond the constitutional authority, and in many cases the appropriate regulatory authority, because these are the areas where sometimes local governments can go overboard and get themselves into trouble. But by and large, just about everything that I've put up, communities are doing, and they have successfully staved off lawsuits. And again, it's just a matter of degree. So thank you.
Good morning. I have a little more plain vanilla PowerPoint here. Thanks, Adam and the law review, for the opportunity to speak today. The symposium has been fascinating so far. I really enjoyed yesterday's panels, and I hope that I'm going to add another element today. So my topic, as it says here, is retail sprawl and the environment. We've sort of, each of us avoided the word big box just to sort of make it elevate the discussion tone a little bit. But when we were talking about the topic, one of the issues that comes up repeatedly with retail sprawl is that, particularly if you read the websites of the environmental organizations, they're always talking about the adverse environmental effects of the big box store, which leads to two questions. What exactly are those consequences, and what difference should they make? And so after sorting through a pile of environmental impact statements done for big box stores and looking at the legal environment a little bit, the bottom line, I think, is that defining environment broadly, most retail sprawl does have environmental effects. The precise effects vary widely based on the project and the location. Of these effects, some of them implicate the standard environmental regulatory environment, and some don't. All of them, however, are of potential interest or concern to the environmentally conscious local regulator. So of the tools that I looked at, it seemed to me that the most useful would be the State Environmental Policy Act, or SEPA, that many states have adopted to ensure that the environmental effects of particular decisions are considered and addressed. And ideally, for a local regulator whose biggest problem might be, indeed, what is my problem here and what are the issues that I need to be worrying about, the environmental impact statement offers a source of information and a way to guide and support a reasoned and informed decision. Now, I should offer a couple of notes up front here. First, As you know, I come to this from a background of being an environmental regulatory lawyer, and when you've been working for big manufacturers, auto companies, electronics companies, and power plants, the notion that a store poses an environmental issue, at first invites, yes, really. But over the past 35 years, I would say the environmental laws have addressed a lot of our the major effects of large conventional polluters. And so the issues that we talk about with big box stores really are on the frontier of our remaining environmental challenges. And here I'm thinking about non-point source pollution, which is polluted runoff, and climate change, which I'll talk about this morning. So the environmental topic is timely, deserves some attention, and indeed stores like Walmart, fully recognizing that environment is big, have recently, over the last couple of years, started touting their own environmental reforms. Couple more points. By and large, the most aggressive users of environmental concerns admittedly have not been towns. They've been citizens groups challenging whatever the town decided to approve. But some towns have used environmental issues. And then finally, of course, like Dean Salkin, I will be mentioning store names. I have no particular, they're solely as examples. I have no particular opinion about or vendetta against any particular store chain. And with that, we have our demon, Walmart. Okay, so just defining the issue from an environmental perspective. Look at the store. What exactly do we see here? Well, building this store from an environmental perspective, for starters, building this store replaces whatever was there before. Now, in an urban area, that's just going to be another building. In a more suburban or rural area, usually this will replace open space or a farm. So we lose a natural or cultivated landscape, and we gain about 20 acres of store. We can assume that the store will be large, featureless, and generally unattractive, which invokes some of the issues that Dean Salkin talked about. The store consumes energy and lighting. It generates some emissions from heating and cooling. And most importantly, from an environmental perspective, you look at this large store with its large parking lot and its large flat roof. These are what we call in the jargon impervious surfaces, which means that they generate large volumes of runoff when it rains. And the runoff then is polluted, contaminated by substances that are on the surfaces, the seal coating on the parking lot, lawn chemicals, other fertilizers in the garden center, bits of old tires, and so on and so forth, all materials that can contaminate natural streams when they run into them. And the parking lot, as you see, is filled with cars who emit pollutants when they arrive and when they leave, and the older the car, the more pollutants they emit. Now, the impact of stores is debated a little bit. Usually the assertion is that they increase overall air pollution by drawing cars from far away. So they cause people to take trips farther than they would ordinarily. The counter response is yes, but once you get there, it's one-stop shopping. This is something that the technical air gurus try to work out in their formulas for evaluating air effects. In any event, there's probably locally concentrated air pollution right around the store. When the store moves out, it leaves a big empty shell, which Dean Salkin talked about as one of the issues that big box stores raise. And then more generally, the existence of big box stores themselves can be seen, and I think this is probably at the root of a fair number of objections, as fostering a sort of a culture of consumption, more stuff for less money. Now here I have to add that the other alternative, less stuff for more money, involves so many economic, social, and policy considerations that we're not going to go into that. So the environmentally, faced with this, the environmentally conscious planner may well ask, right, is any of this a problem? Does any of this offer a reason, offer a legal hook to either refuse to admit or to regulate this big box entrant? Now, at this point, I had planned to go through some standard environmental requirements and explain how they apply, but I realized the message in each instance is pretty much the same, so I'll summarize. Standard environmental effects of big box stores that are taken into account in sort of our standard environmental regulatory repertoire derived from federal law implemented at the state and sometimes the local level. Obviously, stormwater, polluted runoff, a very important implication of the big box store. And here I would mention that when you saw Dean Salkin's pictures of the big parking lot and then the parking lot broken up with trees and tree islands, sometimes those are required as a means of breaking up the impervious surface as one of the stormwater runoff controls. And hidden beneath those planter boxes are various mechanisms for channeling and retaining rainwater. So that's an issue. Oh, and here's one of the technological responses, which, if you look at it, the bioretention basin is a highly engineered hole in the ground where the water flows and is held and percolates down. Okay. Air quality effects vary depending on whether you're in an area with relatively clean air or what's called a non-attainment area, an area with relatively dirty air. Wetlands, siting big box stores in wetlands tends to be an issue. And then, of course, our friends, the endangered species. So all of these involve federal requirements implemented at the state, sometimes the local level, for wetlands and even endangered species. There are, in addition to federal requirements, sometimes state and local requirements. But in each instance, the goal is to allow economic activity while regulating the consequences. The purpose is not to keep the store out. The purpose is to avoid environmental effects. Now, the wetland and the endangered species can prevent a store from siting in a particular location if impacts on the wetland or the species can't be prevented. But usually the idea is you mitigate the effects, allow the store, and move on. So that is why, in the case of my hypothetical, conscientious urban planner, I focused on the value of the environmental impact statement, which brings us to state environmental policy. Look at that. You know, usually it's a rule that you never use a graphic that undercuts your argument, and this really looks ugly, okay? But I will, as we go along, I'll explain. It's not really as bad as it looks, okay? So, and there are reasons for this. So a little background. 1970, Congress passed an innovative law, the National Environmental Policy Act, or NEPA. The purpose of NEPA was to require federal agencies to consider the environmental effects of their decisions before they would decide. And it didn't impose any new substantive requirements. The sole purpose was gather information, put the information in front of the officials, and have them think about the environment. And this has had, at the federal level, a profound impact on the way that federal agencies make decisions. So following the example of NEPA, at least 15 states have their own environmental policy acts modeled on NEPA, which we call State Environmental Policy Acts, or SEPAs. And they follow generally the same model as NEPA with some significant differences. So, for instance, on my hideous slide, there are, in fact, 3 different processes portrayed. The first step is there a possible environmental effect? If no, you're done. That's the top bit. If there might be, but you're not sure, then you go to the middle, which is the short-form environmental assessment. If you're absolutely sure, you go straight down to the bottom, the long-form environmental impact statement. And they tell you how long each of these takes. The first step can take 5 minutes if the answer is no. The second step, they say 3 to 12 months, the environmental assessment. The third step, 1 to 2 years, the environmental impact statement. Okay, so that one is ugly, down at the bottom, all those little boxes. Now, in most states, a SEPA covers only state action. That is to say, a state regulatory agency has to make a decision, issue a permit, whatever. Then you have the environmental impact statement requirements. So, for instance, in Wisconsin, where the state issues stormwater permits, then the state considers the impact of a store as the permit is being considered. In 6 states, even the regulatory actions of local governments require environmental impact statements if there's likely to be an environmental effect. So if the big box store requires a zoning, rezoning, a variance, even just a building permit, you might need an environmental impact statement. So that's NEPA, the SEPA, and now I introduce the LIPA, which is it is also possible for localities to adopt their own environmental policy review requirement, if they want to, even if there's no state-level SEPA. And the theory here is the breadth of the local government's police power, their delegated power to zone and manage land uses, and their home rule power. So if there's no inconsistent state statute, a municipality with home rule power usually has the authority, or can have the authority, to adopt its own impact review requirement. and there are towns around the country that have done that. So the SEPA is a useful mechanism for a citizen activist because it's open to public comment. But of course, the main purpose, the formal purpose, is also includes also informing the local regulators. So pertinent features here, the SEPA covers a range of environmental effects. And I just grabbed this from an actual environmental impact statement for a store in Northern California. This is a list of the environmental issues they considered, and you can see it's pretty broad. It goes beyond what we would expect to see when we open up an environmental law textbook. What statutes do we cover? There's a lot of stuff in here, aesthetics, and down to urban decay. So the broad array of effects can be considered environmental effects here. And as under NEPA, the effects to be considered include cumulative effects of similar decisions, which is where Dean Salkin was talking about regional impacts. In an environmental impact statement, store here, store across the political boundary, you have to consider them both, because there would be a cumulative impact requirement. And importantly, a feature of SEPAs is they have a mitigation requirement. That is to say, identified effects must be mitigated before the impact analysis can be approved. Okay, this is a difference between SEPAs and their original statute, the national statute, NEPA. Although generally, I'll have to say, a proposal can be approved even if not all effects are mitigated, but the town has to offer a reason. It has to say, we considered this, but for a variety of important countervailing reasons, we're going ahead anyway. So the SEPA imposes requirements in addition to other requirements. This is another layer of review, which is good or bad. I mean, if you're a developer, this is annoying, it's costly, and it's time-consuming. If you're a citizens group, you love it because it can foster litigation, challenges, and disputes that will delay the project. For a town, if taken seriously, in the spirit in which the requirement is enacted, it can be a useful decision-making tool. And I've seen instances where doing an environmental impact statement raised awareness of issues that hadn't previously been noticed. Traffic effects they were aware of, the air impact they were not. Stormwater effects they figured there would be, residual effects after permitting they were not. So the environmental impact statement gives useful information. Can a locality use information in an impact statement to deny permission? Now here's a situation where the case law is sparse, well, virtually non-existent, but general principles of land use law suggest a few conclusions. If what's being asked for is a zoning amendment, that's a legislative decision, a policy-based decision. It'll be upheld as long as it has a rational basis. If an environmental impact statement uncovers a result that the town finds to be an unacceptable effect, even if environmental regulations don't cover it, don't prohibit it, then that can be a valid public policy, public welfare basis for saying no zoning amendment, okay? If the permission being requested is some other form of regulatory permission, a use permit, a zoning variance, even a building permit, in that instance, you have specific legal standards that govern whether or not the town should approve the request. And those SEPA laws don't purport to change those. And so in that instance, the role of the environmental impact statement really depends on the type of approval being sought and the standards that govern it. So for instance, however, with a zoning variance, in theory, it's very difficult to qualify for variance. There's a series of requirements that most local ordinances have, but in addition, a variance can be denied if it would be against the public interest. So if you have an environmental impact statement that allows the town to say, no, on the whole, this would be against the public interest, then you can decline to approve the variance. So the precise role of the SEPA will depend a lot on the type of approval being requested, the standards that govern it, and whether the information in the impact statement presents something that's permissible to consider. Now, objections to SEPAs focus on their cost and the delays they impose and the suspicion that they're being used for the wrong reason. Cost and delay, absolutely, yes. Costs more to do this than it was not to do this. Delay, yeah, it does take longer. And that's why over the years states have worked on sort of streamlining this to the extent they can. The NIMBY thing, actually, that covers something that came up yesterday in our panels. There's the, do you mistrust local governments on the ground that they're captured by developers, ill-informed, and not very smart, or not? And here we have, on the one hand, our own factual observations, assumptions, and views, and on the other hand, I would say that the standard judicial line, which is that we must presume good faith, conscientious activity by regulators unless, we have actual evidence of payoffs or whatever. I mean, but the judicial presumption is you presume good faith, conscientious regulators. You can't, as a systemic matter, assume the opposite. And so that's why my presentation assumes the conscientious environmental planner who really does, or the city planner who really does want to know what are the environmental issues, what difference should they make. Which brings me very quickly to climate change, because there's another issue here, right? Climate change is the hot environmental issue du jour, and has come into the big box issue debate, specifically in California, of course. California has a SEPA, doesn't look any nicer, any prettier, any shorter than the North Carolina one, I know. But it does require, as other SEPAs do, consideration of environmental effects of decisions, and they specifically include climate change. And also, as well, California has a recent state statute directing the state to reduce total greenhouse gas emissions statewide by a particular time, 2020. So over the past year or so, there's been a lot of climate change-related activity in terms of local planning in California. San Bernardino, the state attorney general, recently reached a settlement with the county for the county's failure to address climate change in its plan, in its growth plan. And there are a number of lawsuits filed, mainly by a group called the Center for Biological Diversity, challenging decisions to approve Walmart's in particular on the ground that the environmental impact statement didn't adequately consider climate change effects. So, what does this mean? Well, the California laws, like the rest, environment's defined broadly, effects include cumulative effects. What are cumulative effects? Effects that are individually limited but cumulatively significant, which is kind of a textbook description of effects that have caused climate change. And there's a growing scientific and judicial consensus that even tiny effects on the environment can contribute to climate change. If so, climate change considerations in an environmental impact statement, and I just sort of grabbed this list from the website of the Center for Biological Diversity and just included the ones that are possibly relevant to a store. The impacts that you might need to consider are pretty wide-ranging, and a recent impact statement conducted for a Walmart in Suisun City, California, includes all of this in its evaluation of climate effects of the store. So what does this tell us about the last step in the process? Evaluation of alternatives, identification of mitigation measures. This step is required so that regulators can take the information and say, okay, now what? Right? What's the point of all this? What are we going to require now? And here, again, I have a list of suggestions from our friends at the Center for Biological Diversity. Alternatives, which means do a different project, basically, or mitigation, same project, but change it. Select a location to reduce traffic, put it near a bike route, tap into local mass transit. I look at that and I say, right, my 64 cans of cat food and my baby stroller are going to go home on mass transit with me. But this is an alternative that has been identified. The green building, the more energy efficient store, the store with the windmill in the parking lot. This is the kind of thing actually that Walmart is working on now in their green initiative, not only for a green image makeover, but also to cut costs. And actually, this sort of ties in again with our panel yesterday. One of the things I'm curious about in the corporate governance context is, given some of the views yesterday about corporate governance, how do we consider and address the issue of the responsible corporation? what do we think of that, and how do we explain it if we think they're only interested in shareholders' short-term returns? Store can change various other practices, transportation practices. Walmart has placed an order for energy-efficient diesels, redesign of the diesel engine to improve energy efficiency for their diesel fleet in future years. And then here's more interesting, mitigating unavoidable effects. And some of the suggestions: support mass transit in the town, not necessarily at the store, but generally in the town. Retrofit buildings nearby, not your building, but other older buildings. And this is sort of a whole open door of interesting ideas, and Dean Salkin cautioned this is where towns get into trouble. And for land use gurus, this is where you run into what are called Nolan and Dolan exaction issues. You know, how far can we go? Saying, yes, you can do this as long as you do all this other stuff. None of this will prevent a store from being built, right? I can't imagine any of these chains abandoning California. But it will slow the proliferation of retail sprawl. And just in, what about other states? Well, a lot of other states are adopting climate action plans. Other states have SEPAs. I'm not exactly sure where this is going, but I can say that the climate change debate is changing every day. And we have, every day in the news, climate change decisions that seemed utterly unthinkable even a year ago are being made across the nation. So one possibility, for instance, would be a locality adopting a LIPA and then considering climate effects. So the bottom line here on my little environmental topic, in terms of the current national environmental agenda, the greatest contribution localities make is controlling runoff from stores. That's because that's, off the current national agenda, that's the biggest environmental effect of the stores. And footnote, it's a little irony that with climate change, some of the most active entities are not only states but localities. There's 500 localities that have signed on to climate action plans. What environmental requirements pose the greatest likelihood of halting a store if that's what you want? I'd say wetlands, endangered species, or local environmental regulations that I didn't address because there are thousands of them, tree protection, open space, that sort of thing. But SEPA review offers the advantage to me of requiring a broad-based consideration of environmental effects, allowing a town to limit the effects of development that it finds damaging without imposing some sort of categorical prohibition. This strikes me as a more nuanced approach that works better for a municipality that is trying to balance a variety of considerations. And with any luck, at the end of Dean Salkin's suggestions and mine, we go from this to this? Well, anyway, okay. Thank you very much.
Hello, Cleveland. I've always wanted to say that. So, seriously, I appreciate the hospitality of Adam Griffin and the students and the faculty. This has been wonderful. It's my first trip to Cleveland, and it snowed, so that's great. But what I'm going to do today is I'm sort of the diversity on the panel. I'm going to describe the sort of seamy underbelly of some of these local land use controls that implicate constitutional problems that I don't think have been adequately addressed yet in the courts, although there's some indication that these suits might become a more frequent occurrence. So what I'm going to do is just briefly describe the problem, summarize the Dormant Commerce Clause doctrine, which you've heard a little bit about yesterday, and I'm going to describe the Dormant Commerce Clause doctrine not in the tax context, but in the non-tax regulatory context. And I hope that I will be able to do so without inducing dormancy in anyone. I want to mention the cases, and luckily there are just a few, just really a handful of cases here that address this problem. I'm going to also explore the question a little bit about why this claim, which initially when I began to look at it I thought was would be a really robust one, has failed to catch fire in the courts, and then offer a few observations about possibilities for the future. Well, originally I started looking at this a few years ago when I began reading about ordinances, and these are first generation. The things that Patty was talking about and the things that Catherine discussed are much more nuanced. And the old size cap ordinances were pretty blunt tools. It basically said either you can't build a retail establishment that was larger than X thousand square feet, or in order to do so you had to get a special use permit that may or may not be forthcoming, depending on your willingness to sort of comply with the rules and regulations that the locality imposed. Now, there are mixed motives for passage, and you've heard both Patty and Catherine talk about the legitimate ones. Environmental concerns, aesthetic concerns either. But if you noticed in one of the slides listing those regional plans, there was also another motive in there, and this is the motive that I'm going to focus on, which is the protection of existing businesses. And any time a state or local government passes laws that intend to protect existing in-state local businesses against out-of-state competition, you implicate the Dormant Commerce Clause doctrine. Well, what is this? For those of you who, if it's been a while since you've had constitutional law and all you think you know about the Dormant Commerce Clause is that it involves mud flaps and the lengths of trucks, let me remind you, the Dormant Commerce Clause doctrine is a judicially created set of limitations inferred from the power given to Congress over interstate and foreign commerce. And it limits the ability of state and local governments to burden or discriminate against interstate commerce. And discrimination is really the organizing principle for triggering more heightened versus deferential standard of review. If a law is discriminatory, if a case is made out that the law is discriminatory, the government must demonstrate two things. It must demonstrate that it has a legitimate, that is to say, non-protectionist local interest, and that there are no less discriminatory means available to it to effectuate that legitimate end. Non-discriminatory laws that nevertheless are alleged to burden interstate commerce, the challenger here bears the burden of proving that the burdens on interstate commerce clearly exceed the putative local benefits. This so-called pike balancing I'm not really going to talk about very much because, frankly, it just doesn't do much work anymore in the Dormant Commerce Clause doctrine. You'll see it, courts talk about it, but the Supreme Court has not invalidated a state or local law using this balancing test in something like 25 years. All right. As I say, the discrimination sort of virtually decides the case, and discrimination can be proved in a number of different ways, and this makes the Dormant Commerce Clause rather unique. There's the easy cases, which involve facial discriminations, that is, a law written with an explicit geographical reference in the law and treating out-of-state goods or economic actors less favorably than in-state goods or economic actors. Facial discrimination is almost always invalidated with very few exceptions that I won't go into. Second, the Dormant Commerce Clause doctrine you can have heightened review triggered if you have facially neutral statutes that nevertheless have disparate impacts or discriminatory effects on interstate commerce. And then finally, you can demonstrate that if there is discriminatory intent, either of those, with a facially neutral statute, discriminatory intent or discriminatory purpose, are, according to the U.S. Supreme Court, and there's some federal judges who seem not to believe this, including the one who decided the California case and the Turlock v. Walmart, which I'll talk about in a second, that motive alone is sufficient to invalidate a protectionist motive, if proven, is sufficient to invalidate a law under the Dormant Commerce Clause. Okay. When I began to research the issue and try to look for examples of size cap ordinances that I was reading about in news accounts, and you've probably had this experience where you see an article in a newspaper and you think, wow, there's a really good issue there. And then after you sort of dig a little bit behind the story, you find that the reporter oversimplified things, or that there were details that were left out, et cetera. In fact, when I began to pull some of these size cap ordinances or formula retail ordinances and the like, I was surprised by the ingenuousness of their supporters. Many of them were actually quite explicit about the intention of protecting existing local businesses from out-of-state competition. This most often occurred whenever you're talking about the big box stores or category killers. What happens to Joe's Ace Hardware, or just Joe's Hardware when Home Depot comes in? What are we going to do about Joe? How are we going to protect Joe from losing his business, even though Joe may have been charging people $25 for a hammer for the last 50 years? Get into that. We'll talk a little bit about whose interests are being safeguarded here in just a second. It is true that they are almost always facially neutral. That is, no one is sort of ham-handed enough to write laws specifically targeting out-of-state companies. But again, when you dig a little bit, sometimes you don't have to dig very far, you just read the purpose. You get the sense that they aren't worried about a successful store one town over opening up. They're worried about stores coming in from out of state. These impacts of the laws of formula retail or the size caps fall almost exclusively on out-of-state economic interests, and like I said, are intended to do so. The other thing that I was struck by occasionally was that sometimes that the laws are written either, it sort of makes you wonder why they set size caps at a certain size, like 20,000 square feet. I mean, my suspicion is that lots of existing stores, like even local grocery stores, probably come in at just under the size cap that they tend to set, so that you don't have any problems with existing businesses. Other times, I've wondered where the evidence is that 50,000 square feet as opposed to 20,000 square feet as opposed to 75,000 square feet, that choice is linked in some meaningful way to the concerns that the regulators are trying to abate. And I wonder also whether the sort of blunt tool of caps, et cetera, whether the legitimate interests, the aesthetic concerns, the environmental concerns, whether those can't be met by some of these more nuanced or more sophisticated regulatory schemes, assuming that really, environment and aesthetics are really there as part of the concern, as opposed to just sort of naked economic protectionism. Well, here are the cases. There are just four. There's one, East Hampton successfully kept out an A&P grocery store by rewriting, by placing a moratorium on the issuance of permits, and then in the interim, this is a tactic that you'll see. They explore, there's an expression of interest. There is the planning council, the town council, or the county commission gets wind of it. They impose a moratorium. During the time of the moratorium, they rewrite the law to require a special use permit or impose a size cap, et cetera. The A&P East Hampton case was of this nature, and also the Walmart v. Turlock, which is a recent case, also involved the requirement of additional permitting requirements for so-called discount superstores that met sort of statutory definition. In both of those cases, the Dormant Commerce Clause arguments that were made by the stores were rejected by the courts. The Island Silver and Spice v. Ala Mirada, and then the Coronadans Organized Retail Enhancement case, those both involved the formula retail chains. And as Patty noted, they came out different ways. The Island Silver and Spice case, the judge struck it down. It is, and I'll say a little bit more about both of those cases in just a second. In the Turlock case, as I mentioned, Turlock, California had imposed discount superstore ordinance and had required, it sort of was really trying to keep Walmart out. Particularly, I think one of the big issues in California has been competition by Walmart and other Target and some of the other that have a large grocery component to the superstores, and that a lot of the existing grocery stores were feeling sort of pressure. Now, Walmart, of course, the ordinance was not facially discriminatory, so you had to argue either discriminatory effects or discriminatory purpose. The court rejected both, despite evidence, pretty clear evidence, I think, that the intention of this law was specifically aimed at keeping Walmart out. And the judge dealt with this by simply saying, well, no Dormant Commerce Clause case from the Supreme Court has ever invalidated a state or local law solely because of evidence of protectionist purpose. Now, that's just not an accurate statement of the law. And so the judge inferred from that doubt that protectionist purpose was a sufficient condition to result in invalidation. Again, that's not a correct statement of the law. The judge is being disingenuous. Was it enough that the law should have been invalidated? I'm not so sure. Although it was a pretty the evidence of protectionist purpose was pretty blatant, I thought, from the record. And this is the record that was these were the facts that the judge reported in the opinion. On discriminatory effects, it's harder to know. For reasons I'll talk about in a second, it's not clear. The Supreme Court has never been clear which sorts of effects are discriminatory or how discriminatory they need to be. But there are some cases that suggest that if you strip competitive advantage, if you invidiously level the playing field so that out-of-state producers are forced to sort of compete with one arm tied behind their back with local producers, that's sufficient. Now, the judge in the Turlock case said Walmart had presented no evidence that it would be harmed by not being able to locate or not being able to build as big a store as it wanted to. And, maybe that was bad lawyering on behalf of Walmart. I think that, or maybe they presented evidence and the judge just discounted it. It's hard to know from the opinion. I'm sure everybody's litigated. Sometimes you think you put on all this evidence only to see it dismissed in a single sentence in a reported case, The Island Silver and Spice case was interesting. Here you had owners of a store who had contracted with CVS to sell their sort of, I don't know, it sounded like a shop that sort of sold tchotchkes, in Islamorada, and they wanted to sell out. The couple was retiring, and they contracted with CVS. CVS was going to come in and build a pharmacy, and in the meantime, there was a formula retail ordinance passed. They went to get the permit. They were denied permission. They argued that since there was an exception for professional services and there would be a pharmacist in there, that they fell under the professional services. The relevant body agreed and then reversed itself like a week later and then amended the ordinance to ban, to specifically say that pharmacies were not included in the professional services exemption. As a result, CVS pulled out, and the couple lost, the chance to really make money on their store, and were left without. They couldn't run the store. Nobody wanted to buy the tchotchke shop that they had run for those many years, and they couldn't. And the only other businesses that would want the kind of space that they had would have been chain stores, which were now sort of off limits. The judge in that case, however, struck it down and said that there was proof of discriminatory or protectionist purpose. Apparently this was passed, and there was a deposition reported in the case in which somebody said, well, as I understand it, we passed this because so-and-so didn't want the McDonald's to come in. As the plaintiff's attorney, I'm sure they were very grateful to get that kind of testimony. Further, so they applied heightened scrutiny. Remember, just because you present prima facie evidence that there's a discriminatory purpose or discriminatory effects, the burden just shifts back to the city to show legitimate interest and no less discriminatory means. The city's argument was, well, look, Islamorada we want to remain a funky little Keys beach town, and CVS isn't consistent with that. And the judge rejected that on a couple of grounds. He said, "Are you kidding?" He said, we don't have any historic district. I mean, this isn't Key West. There's nothing here to protect. There's no, we don't have any distinctive identity that's worth defending. So, and then he noted that a lot of different chain stores, the county had, the regulatory body had taken the position that retrofitting an existing store didn't implicate this retail. So there were a lot of chains. There was even another pharmacy, which also makes you wonder about what was going on in sort of the background. There was a chain pharmacy, like an Eckerd's or something, that had been put in somewhere because the building had sort of changed hands. It had been an existing pharmacy that had sort of sold out and then converted to a chain. And the regulatory body's position was that, well, there was continuity there. It wasn't changing the nature of the business. Okay, so why are these Dormant Commerce Clause claims failing? I mean, the Alamorada case is on appeal. The judge's opinion, the reasoning on the Dormant Commerce Clause, he just sort of looked at it and said, yeah, this is discriminatory, and struck it down. I would, if I were the couple, I wouldn't be cashing, their damages check yet. I think the 11th Circuit might well reverse the case and remand it. So that raises a question: why are these dormant commerce claims failing? I mean, there's no doubt that the economic protectionism motivates, I won't say all, but I'd say a large proportion of these. Well, one problem is, and I was originally surprised by the relatively few numbers of cases and the fact that they haven't sort of multiplied. But I think the lack of regional planning means that, if you encounter resistance, if you're Walmart or if you're Home Depot and you encounter resistance in one locality, you're going to go to the next county, which may be quite happy to have you and your tax base move in and not cause you any problems. The second, I was thinking about zoning laws themselves and why this idea of local discrimination seems to be treated so much differently. And I came across a great article recently in the Yale Law Journal by Jim Whitman, who is a comparative law professor at Yale. And he was talking about the difference between Europe and the United States in terms of competition laws, in terms of our attitudes towards retail. And he said that he thought that American laws on balance were more consumerist oriented, that the consumer welfare maximization was sort of at the heart of many American laws, whereas many European countries still retain this very producerist oriented element, with store closing laws, with bans on sales. There was an article in the Wall Street Journal this December about the Germans were having sales for the first time. There were some Germans who were very, just outraged. It showed the signs. They don't even have a word for sale in German, so it was English. It just said sale. And things like Sunday closing laws, protections from competitors. I mean, all these producerist-oriented laws are common in Europe, and I think that local zoning retains perhaps one of the last sort of vestiges of that producerist orientation in American law. There are lots of historical echoes between the fight against the big boxes and anti-chain legislation that was passed in the 20s and that resulted in the Robinson-Patman Act passed in the 1930s that prevented sort of price discounting and those were deemed unfair competition, and a lot of the laws were producerist-oriented in that they were attempting to prevent quote-unquote destructive competition, where everybody was made worse off, except maybe the consumers because they got cheaper goods. And so I think that is very much present. I think it's still there in zoning. There's still Rick Schrager has done great work not only on the anti-chain legislation, but also he's got a paper coming out in the Virginia Law Review later this year about local discrimination and how this sort of local communities, municipalities fit into this sort of free trade area that the Dormant Commerce Clause protects, how that's been really sort of overlooked. I think also there are problems with the Dormant Commerce Clause doctrine itself. As I mentioned, the problem of local discrimination is a difficult one because if a municipality passes a law that attempts to keep out out-of-state businesses, they may also be keeping out in-state businesses that they don't want in their community either. So it doesn't look like the kind of discrimination paradigm of New Jersey versus New York keeping out goods or Virginia keeping out all other goods. It's more complicated. It doesn't seem like discrimination. I think that the problem of discriminatory effects that I alluded to earlier, that it's just not clear what effects count. There's a case called Exxon v. Maryland from 1978 in which the court rejected a challenge to a Maryland statute which prohibited oil producers from owning retail service stations. So if you were a producer or refiner, you had to divest yourself of all your retail service stations. Now, it just so happened that Maryland didn't have any producers or refiners. And so all of the producer-refiner-owned gas stations were out of state. All of the locally owned gas stations were owned, or the non-producer-refiner-owned stations were owned by Maryland residents. And there was complaints that the producer-refiner stations were getting their gas, this is back in the early 70s, were getting their gas before the non-producer-refiner stations. And the court said, well, you don't have the right to operate your business any way you want to. And the market that is protected by the Dormant Commerce Clause is the market that's protected, not individual firms. And I have no idea what Justice Stevens meant by that sentence, but it's a convenient one to cite if you want to reject a discriminatory effects claim, like of the sort that that Walmart and other big box stores tend to bring. I think Exxon was probably wrongly decided, but it's not going away anytime soon. Similarly, discriminatory purpose. How do you prove it? How much proof is required before you demonstrate that there was a discriminatory purpose motivating? I mean, bracket for a second doubts that people have expressed about whether it makes sense to talk about the purpose of a multi-member body. I frankly think the difficulties on that score are less pressing when you're talking about a local board maybe of half a dozen people. And certainly when you have the meeting and every single person is standing up saying, yeah, I'm glad we're doing this because, we've got permits pending from Home Depot and Petco and all these places. We just need to get this done so we can, chuck them in the trash can. I mean, that evidence is pretty compelling, I think. But courts, I think in part because of the suspicion of making purpose inquiries generally and the difficulty specifically with the lack of guidance from the Supreme Court about how you discern purpose, how you suggest what it is, all combined to make those claims difficult to bring. Also, I think land use lawyers are not very familiar with the Dormant Commerce Clause, and so framing these highly fact-specific kinds of challenges, I think, are sometimes they don't pay very much attention to them. They sort of throw them in, but really they're focused on seeing whether all the statutes were complied with, whether the local and regulatory authorities had the authority to do what they were doing, and these are sort of afterthoughts. Well, what does the future hold? Who knows, right? But I think that that there's some trends that may make these claims even harder to win. One is the U.S. Supreme Court. I mentioned in my question yesterday to Morgan, the court is taking more and doing more with the Dormant Commerce Clause doctrine in the last few terms than it has done probably in 10 years. I think there's a lot of sentiment on the court for continuing to sort of trim the doctrine and specifically narrow the definition of what constitutes discriminatory. That may mean, and one possible place that the court may be headed is simply to say, look, there's facial discrimination, and then that's it. We're not going to get into these close questions about whether facially neutral laws with discriminatory effects or discriminatory purpose, what they are, how you prove it. Go to Congress, get a law passed if you're unhappy, if you feel like you're being disadvantaged. Maybe the court won't go that far, I don't know, but there's certainly, there are at least 2 votes now. Justice Scalia and Justice Thomas will always vote against a Dormant Commerce Clause claim. If you're a litigator, if you're thinking about having a case before the Supreme Court that involves a Dormant Commerce Clause, you're 2 down already, and that's and other members of the court are sort of ambivalent. Prospects for size caps, I think size caps are probably going to be replaced by these much more nuanced regulatory schemes. That's probably a good thing. I think as the focus shifts maybe from exclusion to integration, let's say, integration in the sense of integrating these stores into existing communities, integrating them into the sort of sense of place that communities retain. I think, I'm hopeful enough. You're right, retailers aren't going to abandon California. At the same time, I think that their communities can work creatively to address their legitimate concerns, and maybe there'll be 1 or 2 cases that say, no, you can't do it just because you want to protect existing businesses. It would serve as a deterrent, sort of that the parties end up bargaining in the shadow of some favorable case law that says, no, just because you want to protect all the existing businesses from out-of-state competition doesn't mean you can try to exclude or burden businesses that are coming in. Prospects for retailers, if the economy continues to contract, I don't know that you'll see as much expansion, and maybe the lack of expansion or the slowing of expansion will see some of these conflicts abate. And then finally, one thing that actually may, I think, trigger different kinds of challenges is whether these continue to be acted at the local level or as has been discussed in a few states, whether states are going to step in and try to mandate certain kinds of zoning requirements or mandate size caps or mandate special use permits for stores of a certain size. You're seeing, I don't know where many of those proposals are. I know that they've been introduced. I think if this occurs, then I think you might see some more challenges, and challenges that look more like ordinary Dormant Commerce Clause challenges, where a state is actually acting to keep out-of-state or to burden, the entrance of out-of-state companies into its state. I think that judges may recognize that a little more. One other thing about the economy, I wonder whether if the economy really contracted and people found themselves with less money to spend, whether whether these discount stores may be sort of get a reprieve from the constant barrage of criticism they've suffered, because I think it is true, and that as ugly and unpleasant as shopping experiences they may be, you can buy a lot of stuff for a lot less money, and I just wonder whether how that will play out if again we continue to sustain a kind of economic contraction. But you all have been very attentive. I appreciate your sitting through that, and look forward to your questions or comments. Thank you very much.
This is Professor Denning. You couched the constitutional challenges in terms of the Dormant Commerce Clause. To what extent might there also be challenges under equal protection theory, either as a federal or state matter?
I don't know about. I can't speak as much to state because, of course, that would involve me knowing more than I do about various state constitutional provisions and how they're enacted. I would say that you do see equal protection challenges And almost always they're uniformly fail. I mean, the assumption is that that these will be examined under a rational basis standard. There's no fundamental right implicated here. And as you know, the standard for rational basis is basically there's no review at all. So it's legitimate to regulate in the interest of, as an exercise of police power, and it's not irrational to think that you would protect the environment, protect the economy by limiting the entrance of the stores. So you see them, they generally failed. I think that's why they failed in the 1920s against chain stores eventually, and I think that's why you started to see these reshaped as Dormant Commerce Clause challenges.
Thank you. Thank you. Very interesting panel. I apologize in advance that this is going to be one of those classic examples of where we sort of see everything through our own lenses. And so it's through my particular narrow lens. So let me ask this question about the Dormant Commerce Clause. You're suggesting that it's not a particularly robust doctrine at this point. Is one danger with a more robust Dormant Commerce Clause that it could be gamed? In the sense that you talked a little bit about the in-state, out-of-state distinction, and this wouldn't apply so much to the big boxes, but it would apply to, say, McDonald's. Could large enterprises organize in such a way as to create a federal case simply by incorporating elsewhere? Locally owned McDonald's franchises, simply by incorporating in Delaware, might all of a sudden create not only standing, but also possibly an argument for out-of-state discrimination simply by incorporating elsewhere. I don't know if the doctrine looks through to actual ownership or larger structure or not. So I guess it's sort of an in-state, out-of-state, what is the definition kind of question.
Yeah, that's a good question. And it's not something that, it's something that particularly plagues local discrimination. And there's not a really good, the sort of idea of local discrimination has been under-theorized. The court, actually, there are a couple of cases where the court says, well, just because a law is written so that it affects some in-state as well as out-of-state interests or goods doesn't necessarily mean that it's immunized from even the heightened scrutiny. Now, how that sits with the centrality of discrimination as a sort of organizing or sorting tool is, and the court didn't really explain that, and I sort of hope to look to that. But as far as gaming, I mean, even if you had sort of local franchises, I think, you could say that that they were trying to keep, well, I don't know. I don't have a good answer for you. I think it's not robust here, I think, because of the difficulties of sort of figuring out what we're doing, why, how local discrimination really functions. I don't know. That's a great question. And I don't have a good answer, so I'll stop.
I just want to mention also on the local ownership that it is potentially a red herring, because even though they own the franchise, they still have to follow all the corporate policies or else they lose the franchise, and they have to have the same menu, and they have to buy the same products, and they have to have the same kind of appearance, so they really are controlled often by an out-of-state interest.
Yeah, that's great. That's what she said. I concur completely. That's what I was looking for.
We'll make this the last question. Yeah.
I guess with the partial exception of some of Brannon's presentation, the one big interest that I found missing from this discussion is the interest of consumers, particularly poor consumers, because obviously I actually live across the street from a Target. I noticed that while I appreciate the savings that I get there, people who make half or one-third of what I make a year, they appreciate those savings a whole lot more than I do for understandable reasons. And so I think it's clear that poor consumers are severely hurt if this is a truly protectionist ordinance that keeps the businesses out. But I wonder, would they not even be potentially significantly hurt, even with the ordinances which don't keep them out completely, but merely increase their costs, thereby increasing the price that they charge the poor, thus making this kind of regulation a form of redistribution from the poor to the more affluent, who are, at least according to surveys, more likely to be concerned with aesthetic issues or sort of new soft environmental issues. Like, I think the poor are equally concerned with the rich ones, would actually get poisoned by environmental issues, but where it's just a matter of, aesthetic appearance or, when one of the impact statements had cultural values, I bet that's more a concern of the relatively affluent. So I wonder, even setting aside whether courts can legitimately consider this, is there not at least a serious policy issue that what this is really doing is affecting a redistribution from the poor to the relatively more affluent, perhaps under the guise of maintaining community character or whatnot?
I would venture a guess, anecdotally, that if at the beginning of your question you said poor communities that lived across the street, I think that most municipalities probably would say, okay, you can cite the retail or the formula-based business in less affluent communities because they're not coming out and telling the local government, we don't want it. I think it's part of the political decision-making process. I don't think it's right from a social justice standpoint, but I think that lots of policies and lots of things are out there say, inner cities, when you want to do infill, these are great infill projects. So if it's a consumerism issue and if it's that the residents in a particular community, an inner city community who might be less affluent, want it, I think government is giving it to them there. I think that it's in areas that maybe are more middle America where the communities are telling their municipal officials we don't want it.
I'd like to add something to that. Your assumption is by increasing the cost of citing the store, we increase the cost of goods within the store. I think it's more likely that we just reduce the number of stores. There's a wonderful statistic that since 1980, sort of average square footage, per capita square footage of retail space has quadrupled. And if you think that cybercommerce emerged around the same time, I think what you have to conclude is we have a drastic oversupply of retail space, which is confirmed by what happens with the stores. They come in, they sell for a while, somebody else builds one, everyone goes to that one. So all the empty stores tells you that we have a store oversupply issue, and that might be the greatest effect of these requirements.
I think we're going to have to stop there. Thank you for a very interesting